Thank you, Your Honor. Good morning. May it please the Court, my name is Tom Maffey, and I represent the appellant Robert Hayden. With me is my colleague Scott McConkey. The issue in this case is very straightforward. It's an issue that has never been ruled on by this Court, and the issue is whether or not a right of first refusal, what I would call a plain vanilla right of first refusal, is barred by the common law rule against perpetuities.
Did you argue the Uno case to the Superior Court judge?
I was not involved in the case at that point, Your Honor.
Did your client?
I do not believe it was raised at that point, but I can't say for certain.
But that's the key issue in the case.
That is the key issue.
Is whether a right of first refusal is the equivalent of an option to purchase.
Correct.
And Uno says it's not, but that wasn't argued below.
As I say, Your Honor, I don't believe, unless I'm looking at my colleague and he's not responding, so I'm not sure that we know the answer. But I'd like to think that if it was argued, the result would have been different.
No, because the judge doesn't mention it in his...
Doesn't mention it, and writes a decision which, internally at least, says an awful lot that suggests that the result should have come out the other way.
Well, that's why the question comes up. The obvious question is, was it argued below? Because the judge never even mentions it, and it's key to the result.
The facts, as the Court knows, is very straightforward. There were a number of parcels of land in the Hayden family, and in 1981, Mr. Hayden Sr. passed away. Because of a tax issue, his estate ended up transferring a number of lots to a gentleman by the name of Matson. That took place in July of 1981, and Matson then transferred the same property, including the one involved in this case, Lot 94, to a gentleman by the name of Keston. The language at issue is in the first deed from the executors to Mr. Matson. And in the second deed from Matson to Keston, that restriction is referred to by reference. In February of 2005, Mr. Keston agreed with a gentleman by the name of Mr. Bortolotti, who's the plaintiff in this case, to sell the property for, I believe it was $550,000. Mr. Bortolotti's lawyer wrote Mr. Hayden, the holder of the right of first refusal, and said, I have made a bona fide offer to purchase this property. You have rights under the deed. Let us know within 20 days whether you're going to exercise them. Mr. Hayden exercised those rights, said, yes, I'm going to buy the property, whereupon Mr. Bortolotti filed this action to complain for declaratory relief to declare the right of first refusal void, and filed a lis pendens, thereby frustrating the sale. The Superior Court judge's decision was based on 2 points. While he notes that this language in this right is the, quote, mildest form of restriction, he nonetheless says, because it, A, affects the real estate marketplace, and B, is the same as an option to purchase with a fixed price, that it's void under the common law rule. Now, the first point proves too much, I submit. A lot of things, as we argued in our brief, affect title to real estate, and they're not all barred by the common law rule against perpetuities. Secondly, and more importantly, there are numerous cases, including several in Massachusetts, that make a clear distinction between what's sometimes referred to as a preemptive right with a stipulated price to basically force an owner to sell the property to the holder of that right at whatever price is stipulated in that option. And the cases cited by my brother, Certified, Fisher, and all the other cases that he cites from other jurisdictions say that that is the provision which is barred by the common law rule against perpetuities, because it is a restriction on the owner's right to sell the property for any price he chooses. The significant point here, and there is a case which is cited in our papers by Chief Justice Sullivan of the Land Court, in which she, in a very well-worded opinion, said in dicta that a right of first refusal with no stipulated price is not a violation of the rule against perpetuities. That position is consistent with the American law of property, and every other decision that I could find where there is simply what I call a plain vanilla right is not a violation of the rule against perpetuities. Apparently the issue's never come to this court before.
Maybe because everybody assumed it was so obvious.
Perhaps.
Or maybe because this party doesn't have standing.
That's going to be my second argument, Your Honor.
Are there any cases where the would-be purchaser who's been iced out by the right of first refusal has been given standing to essentially resolve the conflict between the owner of the land and the holder of the right of first refusal?
There is no case in Massachusetts. There is a
Rhode Island.
There is a Rhode Island case that's directly on point that says that that person does not have the right to come in and frustrate the expectation of the parties to the agreement.
I know, but I was asking you the other question. Is there any other place that says, somebody who stands in Mr. Bortolotti's shoes has standing?
There are subsequent cases after the Rhode Island case which do temper that in some circumstances. But other than that, I'm not aware of any case that clearly says that someone in Mr. Bortolotti's place has standing to come in and upset the party's own expectations of their arrangement.
Presumably, Mr. Bortolotti might or might have claims against the owner of the land, right?
Well, Your Honor,
I don't know that.
But why wouldn't the plaintiff have standing? Because his interests are affected. There is an actual controversy. He will be unable to buy the land. So why wouldn't he have standing? I mean, I can see your argument on the right of first refusal, but I can't see. I understand, but I don't see why he wouldn't have standing. If this right of first refusal didn't exist, he could enforce his purchase and sale agreement. So he's certainly harmed, it seems to me.
Your Honor, Mr. Bortolotti does not have what I would say the cases say is a legally protected interest. He has an interest in buying a piece of property. That's no different than anyone else in the Commonwealth of Massachusetts.
But he has an agreement to buy it. That is different from anybody else.
His agreement is subject to this big cloud, which is recorded at the registry, which he knows. In fact, as I said, it was his lawyer that wrote to Mr. Hayden and said, I just agreed to buy the property, but I know you have a right of first refusal. Are you going to exercise it? So he didn't go in with his eyes closed. He knew exactly what his rights were. So there was no frustrated expectation on the part of Mr. Bortolotti. On the other hand, what the Rhode Island case...
He's got a purchase and sale subject to a condition precedent.
Absolutely.
Or subject to a condition subsequent, and the fact that it's subject to... And nobody's disputing the terms as between the owner and you, correct?
Absolutely not. The Superior Court judge seems to have said that despite the fact that this refusal is about as mild as it can get, because when you read it, you'll see that there are other provisions in there which do permit sales to spouses and family members, power of sale and a mortgage. The judge seems to have concluded that despite that, and despite the law that does exist, the fact that the world knows that someone else could come in and buy this property somehow or other affects the owner's right to sell the property for the price that he or she wants to sell it for. And, of course, as we look at all these cases, there's no right to compel, Mr. Hayden has no right to compel a sale for any price, clearly.
He can't compel a sale.
Cannot compel a sale.
He cannot compel a sale. In other words, if Mr. Bortolotti had offered, $2 million and the owner, I don't know who the owner is at this stage, didn't want it, Mr. Hayden can't go in and say, look, this is a really good price. This is a really good, you should take this, you must take it, because I want to match it. He can't do that, correct?
Absolutely. And conversely, the owner of the property could say, I think the property's worth $5 million, and I'm not selling it until I get someone to pay $5 for it. Now, I have Mr. Bortolotti who wants to pay $5. Mr. Hayden, I don't care who I sell it to. If you want to pay $5, you can have it too. That in no way chills the ability of that owner to sell at not just any price, but the best price. And in the lexicon of the rule against perpetuities, when I was reminded of something I read years and years ago by Professor Leach, it was something like ending the rule's reign of terror.
Well, if we should agree with you on that point, on the right of first refusal, then it wouldn't really matter on the standing issue.
That's correct. That's correct.
Or if he doesn't have standing, we don't have to decide.
Right, that's correct.
Exactly.
Either way.
But could you clarify for me how the rule against perpetuities affects this factual scenario? How long does that right of first refusal continue? Forever?
Well, Your Honor, under the under more modern jurisprudence, including the so-called second look amendments of 1954, Mr. Hayden exercised his right within the 21-year period after lives in being. So therefore, the right is over, he's exercised his right, it's done. If he didn't exercise it, and it was not part of the future transactions with respect to this land, or, as he's done in some other situations, he's affirmatively assented to the sale, then the right would go away. The statute that was enacted in 1990 only affects instruments after 1990. This instrument was drafted prior to 1990.
So the 30 years doesn't apply here?
Correct.
It's 21.
No, that's the rule, but the 30-year...
The 30-year rule does not apply here, but it certainly does indicate that not only did Professor Leach think that someone should temper the rule's reign of terror, but the Massachusetts legislature has said enough. So even if we were to think about long-term restrictions, A, this is not a restriction, and B, this is not long-term. That's all I have, Your Honors. Thank you very much.
Thank you, Mr. Matthew. Mr. Carpenter?
Good morning, Your Honors. Tom Carpenter for the appellee, Robert J. Bortolotti, trustee. I want to sort of recap the analysis we have to go through in this matter. You do first look at the uniform statutory rule, which I'm just going to call the U-strap, unless there's any objection to this for sake of brevity. The U-strap says that right of first refusals are valid if they're exercised within 30 years of their creation. My brother is correct to point out that the U-strap was enacted in 1990. It only applies to rights of first refusal that are created in 1990 or later. This one was created in 1981. So the U-strap says we have to look at the rule against perpetuities as it existed in 1981. What was the rule in 1981? The rule in 1981 was governed by the common law and a 1954 statute. The 1954 statute, I'm not going to read it, but it's cited in page 18 of my brief. When you do read it, you see that an interest in property, such as a right of first refusal, has to be limited in scope, which this right of first refusal clearly is not.
What do you mean it's not limited in scope?
This right of first refusal, let me read it for you, Judge.
No, I've read it, but
Right.
limited in scope, I mean, there's only one circumstance in which it has any meaning at all.
Right, but it has to be limited in scope, and it has to be measured against lives of persons in being. This right of first refusal, Judge, when you read it, talks about benefiting the party's heirs, assigns, beneficiaries. There's no scope to it. There's no lives in being measured. There's nothing
How
about...
do you rebut the argument that the plaintiffs make about the distinction that the Uno case makes, that a right of first refusal is not the equal of an option to purchase?
There are different options to purchase. Not all options are treated the same, and the trial court judge mentions that. My brother is correct in mentioning that. Options to purchase and rights of first refusal are not exactly the same either, and Uno talks about that. But Uno doesn't talk about that in the context of the rule against perpetuities. Uno is not a rule against perpetuities case.
So your argument is the right of first refusal still is an interest in property that would be governed by the rule against perpetuities.
Absolutely, and that's the leap that the trial judge made. These are both contingent future interests. They both affect real property, and they both contain mutual covenants. And that's the difference. When you look at the certified corporation case, certified states that they distinguish between what they call mere options, which don't affect title to real property, and options which do affect title to real property. And they state that options that concern real estate and are in the form of mutual covenants do fall under the common law rule against perpetuities. The same is true of the right of first refusal in this case. It concerns title to real estate. It's in the form of mutual covenants, Your Honors. It's very reasonable to hold that the certified corporation case would treat a right of first refusal the same way that it treated the option at issue in that case. And the trial court held this. It was not erroneous for them to do that. It's absolutely a case of first impression. This narrow issue, the issue of a right of first refusal that is unlimited in duration and is not for a fixed price, has never been decided in this state. There are other states which have decided, and we're going to get to those. Another interesting point, Your Honors, is that under the U-strap, the Uniform Statutory Rule, options and rights of first refusal are covered in the same sentence. under paragraph 5A, chapter 184A, 5A, the same sentence. They're treated in the same sentence. They're both valid if exercised within 30 years.
But we don't look to use.
We don't look to that, but it's instructive because if
No,
we treat
it doesn't say they're the same. It just means that the legislature's decided for what might be two different things, cows and sheep. Cows and sheep shall be subject to a 30-year. Doesn't mean that a cow is a sheep.
they're not exactly the same. But when you apply them to the rule against perpetuities, Judge, they should be treated the same.
What about the fact that the American law of property states that the right of first refusal should not be subject to the rule against perpetuities because it is not an impediment to the transfer of property?
Your Honor, that's contrary to the cases cited in my brief on pages 23. And if we look at, I'm not going to read you the content from each, but if you look at page...
Well, but isn't there a split of authority? The majority may be going your way.
Exactly.
But the minority goes the other way, and the American law of property goes the other way.
And that is the minority view. The majority is that rights of first refusal, which are unlimited in duration, and are not for fixed prices. Again, this is not a fixed price situation. Violate the common law rule against perpetuities.
But we're considered to be among the states in the minority view, based on the UNO case.
See, I disagree with that with the UNO case. The UNO case, it definitely distinguishes between rights of first refusal and options. And I'm not arguing that they're exactly the same.
Sure.
Okay? But the UNO case did not involve the rule against perpetuities. It didn't discuss rights of first refusals in the context of a rule against perpetuities.
But it made a distinction between the two, whatever they're, two types of interests.
All I'm saying is that you can distinguish between them. That there are different kinds of options. The trial court judge says that. There are different kinds of rights of first refusal. We know that there are fixed price rights of first refusal. There are not fixed price ones. But for purposes of the rule against perpetuities, for this narrow issue, the rule against perpetuities, you should be able to treat a right of first refusal, like the one in this case, the same as essentially an option to purchase, as was treated in the certified corporation case. Now, there are other Massachusetts cases. Stepping back for a second, when you look at this right of first refusal, and we know that the certified corporation case states that a contingent future interest, which this right of first refusal is, it's a contingent future interest, is void unless it must vest, if at all, not later than 21 years after some life and being at the creation of the interest. So when you look at the right of first refusal in this case, you see why it fails. It's unlimited in duration. Pursuant to this right of first refusal, you could have heirs of Mr. Hayden 500 years from now, living on Cape Cod or Virginia or Western Europe somewhere, claiming that they have a right of first refusal on this property by its very own terms. That's why it violates the rule against perpetuities.
How would it pass down, though? I know in this case that the first deed from Hayden to whoever the first owner was, that, of course, was subject to the right of first refusal, right?
Right.
The first deed out of Hayden to the first deed out of Hayden
it was from
Matson.
It was to Matson, Hayden Sr. to Matson.
And that's where the right of first refusal was incorporated.
Exactly.
And when Matson sold to Keston, I take it they simply agreed that the right of first refusal was not exercised. So
Right.
Keston bought the property. The right was not exercised.
Right.
Doesn't it disappear at that point?
Here's the problem with the right of first refusal. The right of first refusal, on its face, it's void on its face, by its very language.
What do you mean it's void on its face?
It's void on its face. Because it's unlimited in duration.
But why is it a restriction on a conveyance? How does it restrict a conveyance? It doesn't restrict the conveyance. The owner can sell it. All the owner has to do is give you certain rights, give the holder of the right of first refusal certain rights. It doesn't restrict the conveyance.
It restricts the conveyance because of litigation, because of uncertainty. This is why we're here. This property should have been conveyed 2 years ago.
No, but as I understand it from Mr. Maffey, either you or the counsel representing your client, wrote to Mr. Hayden and said, "I've made an offer. Are you going to exercise your right?" And he says yes, and that would normally be the end of the subject.
But this is 24 years after this right of first refusal was created. Remember, I just read, you have to have life and being plus 21 years. They don't mention any lives and beings. It's not measured against any lives and being, and it's beyond 21 years. If we go back to the certified corporation case, okay? This is on page 20 and 21 of my brief. It states, since there was no provision for the duration of this interest to be measured by any life and being at the time of its creation, the period of annuities is 21 years, commencing from the time of the execution of the option contract. Now, again, we're saying, and the trial court judge said that instead of an option contract, you're going to say this is a right of first refusal. Treat a right of first refusal the same way. This means that because there was no lives and being measured against this original right of first refusal, the period of perpetuities is 21 years from 1981. That takes us to 2004.
Are you saying that this particular right of first refusal gets passed along to every successor who holds the right of first refusal? It doesn't get extinguished by an intervening sale.
Exactly. The right of first, here's what it says. The grantee of the subject property, his heirs, executors, administrators, and assigns shall not sell or dispose of the premises except after first offering the same to the grantors, their heirs, and assigns upon the same terms and conditions as those in a bona fide offer. It goes on forever.
But once the grantor of the right of first refusal and all his assigns and legatees and whatever, don't they get wiped out as soon as the property has been sold once?
Absolutely. You only get to exercise a right of first refusal once.
Okay. But that, again...
Now, that might be in... That means that as soon as there's a sale...
Right.
Now, there may not be a sale for 500 years. I mean,
Right. And that's why it's void.
It could get devised, passed along through the laws of intestacy or by will or whatever
Right.
for 12 generations. The right of first refusal is still there.
Right, because again, a contingent future interest is void unless it must vest. It must vest, if at all, not later than 21 years.
But
this could vest 50, 100, 200 years later if there was no sale.
But doesn't that occur at the time of the first purchase and sale agreement?
Which one?
That they had notice of. Doesn't the first sale extinguish the right of first refusal?
Well, I hadn't thought about that, but I'd have to think about it some more. But the point is, go ahead.
But just the fact issue on that, though, the sale to Matson would have triggered the right of first refusal.
Correct.
But as I understand it, there was a negotiation between Hayden and Matson, and this right of first refusal that Hayden had carried over into the deed from Matson to Keston.
Absolutely.
Yeah, but that is a new right of first refusal, isn't it?
No. It's the same one.
Why?
It's the same. It's in the deed. It's in the deed.
Well,
It's in
because
the chain of title.
But it was negotiated with different people.
in other words, was it a sale? It wasn't by devise. Right?
There was a conveyance out of the estate of Robert F. Hayden, who was the appellant's father. The executors of that estate deeded the property to Albert Matson. In that deed, there was contained a right of first refusal, which is unlimited in duration.
Yeah, but from Matson to Keston.
It's still in the chain of title.
No, but that's the point at which it would have, because Keston isn't an heir, correct?
No, Keston's not an heir of Mr. Hayden.
Is a consideration given?
For the sale.
Was it consideration given by whom?
By Keston.
Did Keston pay for the property?
Yes.
I assume so.
Okay, so he pays for the property.
Right.
And at that stage, the owner of the property says, I've got to go over here to Mr. Hayden's heirs. And he says, don't do that because I want this property. So I'm going to negotiate with you, the owner, and say, I'll put in the right of first refusal. Now, whether or not Hayden at that point could have sued, I don't even know if he knew about the sale, but whether or not he could have sued at that point, or the Hayden heir could have sued, is we don't have in front of us. But it's not clear to me that that's the same right of first refusal. I know the language is the same.
Okay. As I'm running short on time, I definitely have to get to standing. I believe that the right of first refusal is void, and so standing, I believe you're going to have to look at that. What I ask you to do, I disagree wholeheartedly with my brother.
Mr. Carpenter,
Yes.
let me just say one thing. Don't worry, the light is going to go on. You have a very well-written brief. We will read your brief, and we know you feel strongly about standing.
You
Okay.
can always send us a letter also after the argument.
Only if it raises a new point.
Yeah.
There's nothing more frustrating than that orange light. I
Right.
know that.
Okay. Well, on the issue of standing,
If your client doesn't enforce it, who's going to do it? Correct.
well, the standing is that the Bro case is a good case for my brother, but it's distinguishable by the cases I've cited in my brief. They're on page 26 and 27. And the issue in Bro is that the Bro purchase and sale agreement was expressly conditioned upon a right of first refusal. It was mentioned in the purchase and sale agreement. The difference in my case is that it was not mentioned in my client's purchase and sale agreement, not expressly conditioned upon it. When you read the cases carefully, which I know you will, especially the Greenhall Investments case on page 27, it shows that the knowledge of the right of first refusal is not the issue. The fact that the parties knew about it ahead of time is not the issue. The issue is, does the right of first refusal impact my client's rights? And clearly it does. I'm not going to read you all the passages from Greenhall, but if you look at that, you'll see that the issue is, are my client's rights impacted? They are. He has standing. One final point I want to raise, as again, I guess I'm over time here.
And you usually don't get to raise a final point, but you may do so.
Thank you. I appreciate that. Neither party really raised this in their briefs, but it's definitely worth mentioning because as you really look at the statute, you're going to notice this. The statute allows for reformation of a disposition. Even if you find that the right of first refusal violates the common law rule against perpetuities, Section 6B of the statute states that upon the petition of an interested person, the court may reform the disposition in the manner that most closely approximates the transferor's manifested plan of a distribution and is within the limits of the rule against perpetuities applicable when the non-vested property interest was created. Now, what I would say, my first point on that is...
Mr. Carpenter, did you
Yes.
raise the question of reformation? Has that been anywhere in this case?
It's mentioned briefly, I believe, in my brother's brief, that the fact that the reformation is
In any case, we'll take a look at it, but your time really is up.
I would just say that it's not before the court because, and the trial judge notes that no interested person has filed a petition. Thank you.
Thank you, Mr. Carpenter.